Hi everyone, today I would like to share a real case about how we helped a client whose visa was refused and how she was still able to apply for an onshore partner visa, subclass 820, to stay with her husband in Australia. When you apply for a partner visa inside Australia, one of the key things to understand is something called Schedule 3. These rules apply if you don't currently hold a substantive visa, and for many clients, this can be the most difficult part of the process. What is Schedule 3? Schedule 3 sets strict time limits of 28 days if you don't hold a substantive visa. For example, if you're only on a bridging visa, you may have to meet these rules. Most people need to satisfy three main criteria: 3001, 3003 and 3004. Unless the minister accepts that you have compelling reasons why those rules should not apply to you. Criterion 3001 is the most common. It applies if you try to apply for a partner visa more than 28 days after your last substantive visa expired. So, if your visa ended but you only apply for a partner visa within 28 days, your application is still valid. If you just received an AAT decision and you apply within 28 days of that decision, that also is valid. But if more than 28 days have passed, your application may be refused unless you can show compelling and compassionate reasons for a waiver. Criterion 3003. It only applies to people who became unlawful non-citizens before 1st of September 1994. For most applicants today, this won't apply. Criterion 3004 is the most complex. It applies if you became unlawful after 1st of September 1994 and have not been granted another substantive visa since. To meet this, you must show that becoming unlawful was beyond your control, that there are compelling reasons to grant the visa, that you complied with the conditions of your last visa, that you intend to follow the rules of your partner visa, that you would have been eligible if you had applied while holding a substantive visa, and that your last visa wasn't subject to a no further stay condition. Compelling reasons. So what are compelling reasons? The law doesn't clearly define them. Each case is assessed individually, but must be significant and usually outside of your control. Examples could include a serious illness or an accident, or receiving incorrect official advice about your visa. On the other hand, just being in a relationship or saying separation is difficult is normally not enough on its own. Case study. Let me share a story. Poor Jane again. Jane's husband is an Australian citizen. She had her visa refused and was on a bridging visa for more than 28 days. But a bridging visa is not a substantive visa. That meant Jane didn't meet Criterion 3001. We carefully reviewed her situation and identified the factors beyond her control. We then prepared a strong evidence to show compelling reasons. As a result, Jane was granted another bridging visa, allowing her to stay and work in Australia while her partner visa is to be assessed. This shows that while Schedule 3 is tough, with the right preparation and evidence, it is possible to succeed. To summarize, if you apply while holding a valid visa or within 28 days after it's expired, you are usually fine. If not, Schedule 3 criteria apply, and you will need compelling reasons to get past them. Every case is different, so if you're in this situation, get advice early and make sure you have the right evidence. Thanks for watching, and if you found this helpful, don't forget to like and subscribe for more migration updates.